system, how it's ran, and how it's configured in North Carolina. And so this is not a Mickey Mouse task. This is serious business. This is even more important than drawing our line, because we have to have a fair and impartial judiciary. And so I just ask that this committee just be mindful of that, and that we do the best we can. We look at the information. We take the advice of those who are in the judicial system and who's working every day in this court system, the administrators, the judges, whether they're district or superior or prosecutorial, whatever the case may be. I just want to make the statement that we need to get this right. And so I'm honored to be on this panel, but guys, we can't go fast. This is not a fast process. We have to get this right.
Thank you for your comments, Reverend Moore. I believe that is fully the intent of this committee. It's the reason that the Speaker established this select committee to discuss this matter and potentially pass legislation on to the full House for when we return in October, to give us time to do just that. Just as I've attempted to go around the state, have those discussions with judges. I believe you were at the meeting that I had, and certainly you heard comments, concerns there. If you've got ideas you want incorporated into here, or amendments you want to propose when a bill's brought forth, certainly have those ready, because it's been, I believe we met with your judges in the end of July, so there's been ample time for you to have something prepared based on the conversations we heard that day in Mecklenburg County, meeting with your judges. Let's see, Representative Moore.
Thank you, Mr. Chair. I have a question for Mr. Bullock. And sir, it goes back to the statement you said, with the new proposed maps, there are many jurisdictions that are single county, especially district court judges, that have now been split up into 2 or 3 districts within that county. And you made the statement, we need to look at this and be respectful of these historical drawn districts and not split up the voters. Can you further elaborate?
Yes, Representative Maury. Really, the interest there is just to have that committee keep that in mind, that sometimes for consistency and stability's sake, it's easier to have the full county districts than to have citizens and officers of the court question where they lie within the county on who they're electing, who they get to elect, and who they appear in front of. We just, as the bar, we believe it's probably something that we would hope this committee would consider, to try to keep that as uniform as possible and have whole county districts.
Follow up. Thank you. And in that vein, I mean, if you have a single county district, for instance, Durham, is now being split up into 2, that judge that's elected from, say, 18A, still has jurisdiction over the entire county, so half the voters won't be able to vote for that judge who will ultimately have jurisdiction. Is that right?
That's what I'm under the assumption of. I'm not sure, but I believe so. Correct.
Thank you. And member follow-up?
Follow-up.
May I ask Judge Crosswhite, while he's here, a question?
Yes, ma'am.
Judge, you're the head of the Superior Court, Superior Court judges.
Yes, ma'am.
And the one thing I don't think you addressed, or if you would care to comment on, we now currently have 8 divisions. What would it mean to Superior Court judges to now have 5 divisions in terms of travel time, lodging, answering emergency search warrants? How do you see that impacting Superior Court?
I think it would be, I think it would cause a lot of concerns. For example, right now, I'm in a division that has 9 counties, and I would go into a division, I think it would have 23 counties. So my travel would be from as far west in the state as you can go, all the way over to Durham. So I think there's a couple of concerns, and these are concerns that I am sharing that I've heard from my other colleagues as well. I think the first concern would be the increase in travel expenses because most places we go now, we drive for the day, we can drive home at night. I think if you get out to an hour and a half, 2 hours, you're looking at probably spending the night somewhere. I think that's the first thing. I think the second issue, and again, the concerns that I've heard from that are people with younger families, younger kids might not be willing, who would otherwise be tremendous judges, might not be willing to look at running because they wouldn't want to spend that time away from their young family. So the concern is that certain people that otherwise might consider being a judge might not do that. The final thing that you mentioned were search warrants and things like that. And it would, I mean, if you got a judge, if I'm in Durham and somebody back home needs a search warrant, then they would have to, instead of finding me or waiting until I get home, we sign a lot of warrants at night, a lot of warrants at 4 o'clock in the morning. But if they needed a warrant, if they had, for example, a meth lab that they needed to take down and they needed to destroy, and they couldn't find a judge, then they would have to wait, either call somebody else they didn't know or wait until they could find somebody a day or two later. And that would come, I think, with the increased travel. Now, that being said, those are just some of the concerns that I've heard. But that being said, judges will go where we're told to go, we'll do what we're told to do. Those are just some of the concerns that I've heard from some of my colleagues.
Representative Corbett, is it on this discussion? Gentleman's recognized.
Thank you. Part my ignorance is I'm not a lawyer or in the judicial system at all, and don't know a whole lot about it. But you just made a comment there that trying to locate a judge, you can't locate a judge. Can you explain how that is even possible in the day-to-day time?
Well, I mean, you can locate a judge, but for example, if somebody in Hickory, if they needed a search warrant signed and their judge that they're used to contacting was holding court in Durham, then they had to be out of town. They could still get them on the phone, but they wouldn't be able to get to that judge to have that judge sign that search warrant.
Follow up, Mr. Chairman. Is there, pardon my ignorance again, is there no mechanism in place to allow that to occur currently in North Carolina?
What do you mean to allow that to happen?
Like you're saying you can talk to the judge on the phone, but he can't, what I understood or what I heard you say, he can't physically issue that warrant.
Right, because what we do when we issue a warrant is we have the officer sworn, we review his affidavit, we read that, and then we sign the warrant, and that's done in person. And now, you know, I'll get calls. I get calls several times a week, and if I'm in court, like for example in Concord or Lexington or somewhere else, I'll say I can't do it now, but I'll be home this afternoon. Just meet me at my house this afternoon, or meet me at the office this afternoon, and we can get the warrant addressed then. But if I'm not there, if I'm somewhere that far away that requires me to spend the night, then I'd have to say I won't be back till the end of this week, and they could find somebody else, but
My final follow-up, I think you might have just answered. So what there is the ability to find another judge, I guess is what you just said, right?
Yes, sir.
And is there the ability currently now to provide for an emergency type of situation so it can be handled at a moment's time if needed?
Right now, there's not any kind of an emergency situation in place. If a law enforcement officer needs a judge, for example, if they need a warrant signed, they'll call the judge, and I've got a lot of officers in my phone. They call me, I know who's calling, and I can sign the warrants for them. If I'm not there, I will try to tell them somebody that I know that might be around and have them call that person. So it is not anything formal, but it's the way the system works.
Thank you, Judge. Thank you, Mr. Chairman.
Yes, sir.
On this same topic, I believe Representative Blackwell had a question. Representative Buzz.
Thank you, Mr. Chairman. I also have a question, Judge.
Yes, sir.
Judge, explain to me a little bit how your reimbursement or expenses are handled as a Superior Court judge. Do you get something for travel from your home to, what entitles you to travel? Do you decide when to request it and how many miles? How does it work?
No, sir. Any time we travel outside of our home county, we get reimbursement. We get reimbursement based on mileage, and then if we have to spend the night somewhere else, we get per diem, and we also get room reimbursement for that.
And what mileage reimbursement rate do you get?
I'm not exactly sure. It was maybe 52 cents a mile, maybe 58. It changes periodically, and I'm sorry, I don't know exactly what it is now.
Follow-up. And you mentioned earlier something about judges being able to go home at night.
Yes, sir.
So you just let the administrative office, the court know when and you can go, like if you're in court somewhere in, let's say, Hendersonville, and you go up there Monday and you drive back Monday night, and you go up there Tuesday and you drive back Tuesday, same thing Wednesday, same thing Thursday. You got it all done in the first 4 days, you didn't go Friday. Do you get reimbursed for 4 trips up there by simply requesting it?
Yes, sir, we do. If we travel up there, we just submit where we went that particular day, and we get reimbursed for mileage on that day.
So you figure the state does that because they think, well, if he's going home, we don't have to pay subsistence? Or do you get subsistence because you have to buy lunch up there?
No, sir, we don't get that. The only time we get, and what we call per diem, the only time we get per diem, and that's, I think it's maybe $18 a day for dinner, maybe 12 for lunch and 8 for breakfast, and I don't know, don't quote me on those, but the only time we get that is if we spend the night away from home. If we drive up during the day and we drive back home at night, all we get for a day trip like that is reimbursed for gas.
But the decision about whether to stay and to get per diem and one round trip for 2 days versus going back and forth home is the judge's, and he gets paid for the extra mileage if he chooses to go back and forth each day.
Yes, sir, that's in the judge's discretion, and in all honesty, most judges like to stay home when they can, and so they'll drive an hour and a half. Once you get up to about 2 hours, I think they start looking at spending the night away at that point.
Follow-up?
With reference to the question that I think Representative Torbett maybe was pursuing with you, you are a resident Superior Court judge who also holds court in other counties. Is that correct?
Yes, sir.
As a resident Superior Court judge, you can sign what? Any order that's related to matters occurring in your district from which you are elected?
Yes, sir. Yes, sir.
And can the lawyers or the sheriff or the chief of police, whoever needs you to sign the order, can they bring them to you where you are?
Yes, sir, they can.
Can you sign it out of district?
Yes, sir.
And in addition to you, who else can sign orders for those same judges? Any other resident Superior Court judge for the same district?
Yes, sir.
And anybody assigned to hold courts in that county, what, for that 6-month period, or
Yes, sir.
is anybody else authorized to sign the orders besides the resident judge and the court judge holding court there?
Well, any Superior Court judge can sign an order. So, and that, I think, follows up his question. If I'm not there, like if I'm on vacation or when I was away with the military and I would get a call, I would just refer them to somebody who I knew, to another judge that I knew might be in county over or somewhere close by. So I would refer them to that other judge. And that's routinely the way it works.
Representative Blust?
I have a question for the judge, perhaps the bar, perhaps staff. I think it's a legitimate concern, the number of divisions, and I'm just wondering if there's any research or work done on what is the optimal number of divisions, and when is the last time the number of divisions changed, and why even have divisions? Why shouldn't it, just like in Guilford, if you go into district court, you're getting a judge you voted for. Why do I need to go into Superior Court and get a judge from Davidson County or some other county? What's the thinking behind this rotation? And just, if you could address that, I just wonder why not even have more divisions?
Well, yes, sir, and I can address the rotation. That was by the Constitution. Superior Court judges will rotate, and I think the reason for that was to prohibit maybe judge shopping or favoritism in your local district, and it's a system that we've always used, but it was in the Constitution that Superior Court judges do rotate anywhere in the state.
Follow-up then. Has there been any work on the optimal, what's the lowest number of divisions you could have and still meet that constitutional mandate?
And that's a good question, and I can only answer on behalf of the Conference of Superior Court Judges. We have not addressed that. We don't have an answer on what the optimal amount would be. I think there's a lot of factors that would have to go into that. Travel expenses would be one, and that's probably something that would be better addressed by this body. You guys could justify what you could support or not support as far as travel expenses for judges. But as far as what's the optimum number, I don't know. We've never studied it.
Representative Busk, you should have documents in front of you that were presented earlier from central staff that show the last time the divisions were changed. It's on your desk. We went over it earlier in the committee meeting. You got another question?
One follow-up for staff.
Yes.
What's the minimal number of divisions we could have and still meet the constitutional mandate? And has that ever been litigated?
Churchill?
Representative Wells, I don't know of any litigation on the matter, but the Constitution, as Judge Crosswhite says, does reference that there are to be divisions. It does not set a mandatory minimum number of divisions, but by it being plural, I would say at least two. Past that, we're happy to look and see what we can find to see if there's any further guidance. As you will see from the charts before you, in 1969 there were 4, which were increased to 8 in 1999, where it is stayed.
Any other questions for Representative Doolin?
Thank you.
Or Judge Burke? Okay. Go ahead, Representative Doolin.
Thank you, Chair. I understand judges are volunteers. They volunteer to run for office and to serve, just like we do. We're all volunteers. We learned from our last committee meeting last week that Superior Court judge starting salary is $134,000 a year. What is the daily per diem when a Superior Court judge takes the daily per diem?
Well, it would be a combination of the breakfast, lunch, and dinner meal that it is somewhere maybe in the 30s, and then I think our overnight, our per diem for a room is maybe 65 a night or something like that.
Okay, yes, okay, then that makes it, that's better then. I mean, and it's an awful combination of having to keep track of all that, so I appreciate, that helps a little bit.
Yes, sir.
And by the way, thank you for your service in Afghanistan. You Army JAG?
Army JAG, yes, sir.
Thank you.
So was Major Brooks behind me.
Really?
That's you.
Nice. Thank you so much, ma'am. But
You have to follow up on
I'm
this.
still very serious. But one last thing, one second, I gotta look at my notes. Okay, thank you. Mr. Chair, thank you.
Yes, sir, Representative Doolin. If you find another one, just let me know, okay? All right, Representative Richardson?
Thank you, Mr. Chairman. My question goes back to the fact that if we decrease these districts and judges have to travel and spend more nights in hotels, are you concerned about the safety of these judges, since it has been expressed to us that we do not list judges' home addresses for their safety? So do you see this being a vulnerable situation if a judge has to stay in a Holiday Inn several nights a week on a routine basis?
From my standpoint, no, ma'am, I don't. I mean, I have my home address listed on the ballot. I'm from a small town. It's not real hard to find where I live, and as soon as we leave the courthouse, we're in our cars, and no, ma'am, it may be for others, and I can only answer that for myself, but it's not for me.
Follow up?
Thank you, ma'am.
Judge Crosswhite, I know you mentioned earlier, obviously, I believe, you don't want to put words in your mouth, divisions you'd prefer to keep. I think you're in a 9-county division right now.
Yes, sir.
And you prefer that not to change. You don't want to have to travel outside of that and have expenses. how many counties have you held court in as a Superior Court judge?
Probably close to 50 or 60
So
at this point.
you have traveled outside, and clearly if you've been in 50 counties, you've done it more than one day
Yes, sir.
in your, I guess, close to 10 years of service.
Yes, sir.
Okay, so you currently don't just hold court in those 9 counties?
No, sir. We go anywhere we're assigned. We have our rotation within our division, and that's, I guess, what I was talking about is people, when they rotate in their division, they like to be able to go home, but, you know, we'll go wherever we're assigned to, so we certainly do that.
Do you believe currently with Superior Court judges traveling outside the division, does that put a burden on the budget for travel for judges or for the AOC? I'm trying to understand what you're currently doing potentially could be, increase the cost over changing the divisions and just being accurate with what we're really doing here, rather than saying one thing and clearly we're doing another, since you're home court and respond to that if you will. Along with that, what's the furthest county you've held court in?
I've been all the way to Jackson County in the west and to Brunswick County in the east, so I've covered the whole state. But to answer your question as far as the rotation in our division, like right now my division, I might rotate to Lexington or Concord or Monroe or Alexander County, and in all those places on a regular 6-month rotation, I go home. If our rotation took me all the way to maybe Ashe County or maybe all the way to Durham County, in my opinion, that would be too far to go home. So that's when I would start, even for that 6-month rotation, I would start looking at about a 2-hour drive. I'd start looking at spending the night as opposed to commuting back and forth every day.
But under current law, there's no requirement that if the divisions were larger, that you would have to go to those particular counties. That is an issue the schedule is arranged by the judges, correct?
Yes, sir. Yes, sir. There's a judge in each division that sets the rotation, and I think that's the one thing from this is, like I said earlier, judges will go where we're asked to go. I do think that's the one thing is if there is a larger number of divisions that there be some consideration made so judges might not have to rotate from one end of that division to the other. That would be kind of a substantial work.
And I don't think there's anything that would require that under current law or in the proposed deal as it stands. So I think there's a couple more questions for you now,
Yes, sir.
now that you're back up here. Representative Jordan, you had one, and I believe Representative Jackson.
Thank you, Mr. Chairman. And it was exactly what you were just discussing with the judge, and so that I'm clear about this rotation and this travel and so forth, who exactly is requiring the rotation and assigning the rotation? Is it in statute from the legislature? Is it constitutional? Is it AOC policy? Who exactly controls establishing rotations and assigning judges to do the various rotations that are done now? And then how would that change?
Judge, we can get staff to answer that, Senator Staff
Yes,
can
sir.
answer that unless you,
They can, and I know Judge Warren was here earlier. It's AOC controls our rotation. They control where we go, but there's a judge within the individual division that establishes the rotation for that division. And I don't know if that's answered your question or not.
Mr. Churchill.
Representative Jordan, the underlying premise, as Judge Crosswhite said earlier, of the divisions and rotation amongst the divisions for the Superior Court judges is underlying in the North Carolina Constitution. To effectuate that, there is a statute that I will read in its entirety to you. It is 7A-47.3. To effect the intent of Article 4, Section 11 of the North Carolina Constitution, each regular resident Superior Court judge may, upon each rotation, be assigned to hold the courts either of one of the districts or one of the set of districts as defined in GS 7A-41.1A in that judge's judicial division, subsection to administer the rotation amongst the divisions.
Thank you. Can you state that statute number again, please?
It is 7A-47.3. And it was in the materials distributed last week and available on the web at the committee's website.
Representative Jackson?
Thank you, Mr. Chairman. Judge, I want to follow up with you on Representative Blackwell's question, but it was actually a comment I made last week. I believe you said you get reimbursed actual for your hotel if you stay overnight. Is that correct?
Yes, sir.
Can I follow up, Mr. Chairman? And is that at a set rate, or do you actually submit the bill?
No, sir, it's at a set rate, which is about $65 a night. If it goes over, then that's out of the judge's pocket.
Okay, so if you got assigned, if you lived in Durham County, and you got assigned to do court in Dare County for a week or 2 weeks, and couldn't find a room at $65 a night, that would come out of your pocket to pay for that room, is that correct?
Yes, sir.
Thank you, Mr. Chairman.
Representative Jones?
I just had a question of the chair, if the members are through with Judge Crossway.
Representative, hold one moment, because we've actually got Judge Crosswhite, and we still had a gentleman from the bar here as well, and I'm not sure, Representative Floyd, who was your question? Which one were you?
I have a combination of questions, and I don't know who to address them to, but I'll just have a list of them here, if I may, Mr. Chair.
Yes, sir.
For one is that, Erica mentioned earlier, is that from time to time, the General Assembly to look at the addresses of, I think you mentioned judges, whatever, there. And it just bothers me, we as an elected official, we can post our addresses wherever, we get a lot of unique telephone calls and that type thing. But as it relates to the judges, they can have an unlisted telephone number. It just raises a concern, to me. And then the other part of that is that as it relates to just living within the district, registered here, and then using your legal address. I think that the committee mentioned that they might look at that this coming Friday. But on our economic closure statement, when we fill those forms out, it indicated that all the information is not full developed to the public. I think that that committee might want to look at something similar to that, so at least we can have a true address of that particular person that's seeking that public office. And then the other thing on the list is that perhaps the committee can look at the possibility of when judges claim per diem or overnight stay, may it be the number of miles or hours that the judge would have to travel prior to he or she reached his home destination. For instance, 125 miles, 250 miles, or 2 hours or 3 hours, that the committee can look at that in its policy so that we can have some form of uniformity as it relates to the judgeship and the address and the accommodation for the judges. For instance, the General Assembly, we get $104 per diem per day. You can use it all up or you don't, that's your choice. But I think that we need to have some uniformity as whichever committee that can look at it and come back with with us so that we can have that uniformity.
Was that just, I assume that
There was
comments?
questions and comments.
There were questions in there?
No, there was mostly comments in there for either which committee can take them up and look at it, either this one or this committee.
All right, thank you, Representative Floyd. If anybody wants to respond to any of that, let me know. Representative Doolin, hold on, I'm going.
I agree with you,
Okay, great. Thanks, sir. Any additional questions for either Judge Crosswhite or the gentleman from State Bar? Yes, Representative Moore.
Judge Crosswhite, we're talking about money per diem, travel. What about the actual work of a judge? If you finish a trial, if you're into a trial, it's over at 5 o'clock, do you go home and just do nothing? And start the next day? Do you have any time you're required to prepare, to read any of the law?
Yes, ma'am. Yes, ma'am. There's, the amount of time we actually spend in court is only part of the time. You spend a lot of other time researching, you spend a lot of other time writing orders, signing warrants. If you're the senior resident in a district, you have a lot of senior resident duties, you have a lot of, you have to address a lot of what we call motion for appropriate relief from inmates and things like that. So it's a lot more than just in court.
Follow up?
So if you're in Durham, you're traveling to Dare County 442 round trip miles, the time you're in a car, you're not being able to do your judicial duties, is that right?
Yes, ma'am, unless you do it on the phone.
Thank you, Judge. All right, any additional questions for either of the two? If not, Representative Jordan.
Question, Judge Crosswhite.
Judge Crosswhite? Off to the man today.
Yes, sir.
Thank you, Your Honor. So therefore, a round trip of 442 miles and not getting much done would not be a very efficient thing for AOC to establish, correct?
Well, probably not, but again, I will tell you, we go where we're told, we don't decide where we go. I mean, we're public servants, and we'll, wherever they ask us to hold court, wherever there's a need, we'll go. So it would be up to them to decide, I guess, the efficiency.
Follow.
And then the judge that you mentioned is also involved in that scheduling. Who is that judge?
Well, it depends. It's whoever's the senior judge typically in that division. They're the ones that establish that rotation.
Thank you.
So just to be clear, it's not AOC that's establishing that schedule. It is the most senior Superior Court judge in that division working with the other judges. So you all are essentially coming up with your own schedule. So I assume you wouldn't assign yourself to a county that far off. It continues to be at your discretion.
Yes, sir. If it's in one of our regular rotating counties, it would be up to that individual judge to assign that. If we get assigned outside of our division, those assignments come from AOC.
Thank you.
Yes, sir.
Okay. All right. At this time, there are no additional questions for any of those individuals. We're going to hear from the North Carolina Bar Association. We're going to hear from, I believe, the current president and the past president of the Bar Association, Ms. McNeil and Ms. Benton.
Great. Thank you, Chairman Burr, members of the committee. Good afternoon, everyone. I'm Karen McNeil. I'm a lawyer with Smith Anderson here in Raleigh, where I help corporate clients with their employee benefits issues. And as Chairman Burr has indicated, I'm the current president of the North Carolina Bar Association. With me is Shelby Benton. She's my predecessor, twice removed. Shelby served as president of the Bar Association in the 2015-2016 bar year. She has a family practice in Goldsboro, which has her in district courts all the time. We appreciate the opportunity to address you, and I propose to divide our time as follows. I'll recap the Bar Association's current position on the bill and also what we've learned from a survey of judges that we helped facilitate. And Shelby is going to flesh out those takeaways and then give you some concrete examples of some of the concerns that we've got about how this bill may adversely affect the administration of justice in our state. I'll say at the top that we have no objection to the question here, to the idea of revising judicial and prosecutorial districts. Fair and balanced districts promote the administration of justice. And it's reasonable to reconsider them, as we've said, from time to time, to be sure our resources are allocated efficiently and effectively. The question of judicial districts, though, is an important one, and it's so important that we think that redistricting has to be based on a deliberate and open process that includes the input of an array of stakeholders, judges and district attorneys, clerks of court, law enforcement officers, lawyers, and members of the public. We think only with the input of all the members of those groups can we be sure that the result will work as well as it can for the citizens of North Carolina and warrant their trust and confidence. And it's for that reason and on that basis that the Bar Association has opposed this bill. What I want most to share with you today, though, is what we've learned since we took that position. In early July, we were approached by judges who asked if we would convene a meeting of stakeholders to discuss the bill, and we were happy to do that. Superior Court judges, District Court judges, AOC representatives, prosecutors, and lawyers attended. At that meeting, the judges and DAs decided they wanted to set aside consideration of the potential political implications of the bill and focus instead on the bill's potential impact on the administration of justice. To do that, they designed a survey that they shared with Superior and District Court judges. And the survey asked 4 simple questions. Here they are. Number 1, at the judicial division level, how do you believe the proposed changes may impact the administration of justice in your division? What are the potentially positive impacts? What are the potentially negative impacts? Number 2, at the judicial and prosecutorial district level, how do you believe the proposed changes may impact the administration of justice in your district? What are the potentially positive impacts and what are the potentially negative ones? Number 3, do you have any specific information, data, or stories that might help illustrate your responses to the questions above, or anything else you'd like to share? And number 4, who in your division or district might want to know what you've shared above? The survey went out in mid-July. 43 judges responded, 26 Superior Court judges, and 17 District Court judges. Of the 43, 10 shared that the proposed maps would have positive consequences or no effect on them, while 33 shared that the maps would have negative consequences. The concerns expressed by the 33 judges who foresaw negative consequences fall broadly into 4 categories, and Judge Crosswhite has touched on some of these already. The first set of concerns had to do with increased travel expense and time. Judges commented that the bill would require many court officials to travel further to conduct court business and stay overnight in awesome help, that's great. Stay overnight in more remote districts, and they said that that would result in dramatic cost increases for the state. A number also volunteered that they thought that additional travel time and nights away from home might deter younger and female candidates from seeking judicial seats. The second set of concerns had to do with increased workload. While workloads certainly vary in each district, judges commented that the bill seemed that it would shift additional work onto many of our already overworked court officials. They thought that the proposed maps, if adopted, would make our busiest judges even busier. The third set of concerns had to do with decreased availability in emergency situations. We've touched on that today. The judges commented that because of overnight stays elsewhere, that could hinder their ability to handle after-hours warrant applications. They also noted that critical personnel like law enforcement officers might have to travel further to find a judge, creating inefficiencies and increasing costs for those agencies whose budgets are already tight. And the last set of concerns had to do with the potentially detrimental effect on public trust and confidence in our courts. Judges commented that redrawing maps without input from the public and other direct stakeholders could erode the public's confidence. They said that the process employed was critically important, and they urged deliberate consideration of the available data as well as transparency. Since then, judges have been actively sharing these takeaways with their legislators, as well as personal insights about the impact of the maps in their districts. So at this point, I'd like to turn this over to Shelby, who's going to share some insights about the practical effects of the bill in her district.
Before I get started, if I could just clarify, the North Carolina Bar Association has been in existence since 1899. We're the organization that in the 1930s said to the legislature, you should create the state bar to regulate the profession. But we are the organization that works and comes and lobbies with you guys about various
issues in substantive law, and we try to help with all kinds of other things that assist lawyers in their practices across this state. So we have a different outlook in the situation than the state bar does. We don't keep addresses. We're not the people you're going to come to ask for that information, but we have been in existence for a very long time, and we're the organization that was asked by the governor back in the 1950s to develop the new system, the unified court system that we've all been talking about here. And that was developed in the late 1950s from the Bell Commission, as you all know, and then the implementing statutes and the constitutional amendment took almost 8 years to come into effect. And that process is what you're talking about making some changes to as it relates to these district and division lines. Yes, there have been tweaks over that period of time since 1967 when the district court actually came into existence 50 years ago to where you are today. So saying that looking at this since the end of June to October is enough time for everyone to have the input of all the stakeholders that ought to be involved in this process, we would submit to you is not the right process to make these types of decisions. So if you're going to take it up once in 60 years, we would submit to you that you should spend deliberate and transparent time in making those decisions. So I'm coming to you talking as a district court practitioner. I practice in family court in Wayne, Lenoir, and Greene County. That's the 8th judicial district. And I can tell you in my district, it's a huge effect. What is being proposed is that you would move from the 4th District Court Division, this very small county of Jones that has about 10,000 people in it, and put it into our judicial district 8, which is Wayne, Lenoir, and Greene counties. And we have 6 district court judges to service those counties. This bill proposes we keep the same 6. A district court judge, as you've heard earlier from Judge Brooks, they hold criminal court, they hold domestic court, they hold juvenile abuse and neglect court, they hold juvenile delinquent court, they hold child support enforcement court, they hold civil jury and non-jury court. Additionally, they also manage magistrates. They handle the small claim mediation cases that have to come through, as well as custody mediation. There's a lot of work that goes on. And in the district court division, the districts that have been set up, many of them have built partnerships with other outside agencies, law enforcement, probation officers, mental health situations and providers, and other, even in my district, we have a memorandum of understanding with another mental health provider to come and provide some services for us in our district. And so when you add an additional county to our district, what really happens for us, and I know Representative Burr has heard this because we've talked about it in other ways, is that we would lose court, at least 6 days in court per month, we would submit, because we've got to go hold those other courts. Sure, we can combine some of them together, but it's a serious effect on our county. For me, I don't have enough time to try my domestic cases anyway, because we've still got to hold all the other cases across our 3 counties that we already have. So it's a very serious effect. Additionally, it's how do you staff all of that? How do we build these partnerships? We're not saying it can't be done. It absolutely is something that needs to be studied. But as you move through this process, the opportunity to talk to all of those other stakeholders, when you talk about the sheriff's department, you've heard that talked about. In Mount Olive, North Carolina, that's in Wayne County, we hold court every other Friday. And in that court, we have district criminal court. We do some domestic cases down there on that day. If we get Jones County, we don't hold that court anymore. So that means Mount Olive law enforcement officers have to come to Goldsboro whenever they want to come here or have their cases set. It has been some judicial economy and some services that were submitted to this particular community in Mount Olive. It's about 20 miles from our county seat. It's a nice thing we've been able to do for almost 50, well, at least 50 years now. It's been going on a long time, but our chief district court judge has said to me, not going to happen. So while it might be that you would say, okay, well fine, we're just going to move Jones County back over here and leave it in the 4th Judicial District. That'll be fine. That solves my personal problem, and I thank you very much. But what I would say to you is those are those same type of similar things that happen in these little divisions and districts. It's
particularly in district court divisions, or districts, excuse me, I'm interchanging the name, district court districts. In those districts, many of them have built various partnerships, and you need to look at how will those partnerships be affected by the changes of splitting things up or putting other things together. Particularly when you look at Orange and Chatham County. Our survey had specific information from that. I think some of that information has been shared with members of this committee and other members of the legislature. We just submit to you that you need to take the time necessary, and in a few short months, we would say that you need to spend time looking at these other partnerships and how all these things will be affected, because it affects the administration of justice. It's going to take us longer to hear cases in various places because you simply won't have as much court time. You won't have enough of the other people to service it unless you spend the time looking at it, and then you make the changes in those other resources. And as we raise the age, which I applaud you for doing, is absolutely what needed to happen in North Carolina, but as we do that, the district court is tremendously affected by that. That's juvenile court, folks. That's what you're talking about. And as you move these things, it's just a process. We would submit to you that if you took the time between now and May, the Bar Association is willing to be involved. As you see, we have put in a process, a survey, just that quick. We sent it out. We got 43 judges to respond. To the district court judges, please know, it was only submitted to the chief district court judges. There's only 41 of those. So it's not like all 270 of them actually had it to make responses, although some may have. But I'm submitting to you that this is a process. We are not saying as lawyers, or me, myself personally, or as a bar association, that this should not be studied. That perhaps the administration of justice could be impacted in a very positive way by the legislature moving districts or moving divisions. But from a district court perspective, clearly, it needs to be done in a transparent and deliberate fashion. You need to invite other stakeholders, not in this way where we're just preaching to you and you might ask us some questions. But let's sit down at a table and say, hey, look, this makes a difference in my area, and this makes a difference in my area. And I know that Representative Burr has gone and done some of that in some places. However, the opportunity to really sit down and hone in on what that difference makes and how it affects that sheriff's department or that probation office or the guardian ad litem program that is, again, critical to our juvenile justice system. It's just so important. When you look at superior court judges and moving these divisions, the tradition of rotation has been in our Constitution for a very long time. And it has been the premise that everyone, the judge will hold court in every county in their division. So they're going to move around. And if there's 9, which was created in 1999, I've been practicing since 1985. I practiced in superior court. I handled capital murder cases. I've seen how they move around. And that was back when we only had 4, and we were traveling all over the place. Well, it costs too much money. You looked at it as a legislature back then and said, we need to have some judicial economy here, and let's make it 8. Because that's less travel for people. That was one of the things that was considered back in 99. I'd ask you to go back and look and maybe get some history. But that's clearly what happened. So now you're talking about moving to 5 for superior court judges. Again, a serious situation, because what our premise has been is you travel them all around. I know you could say, oh, well, we're not going to send you to Dare County if you're way over here on the other side, midway of the state. But you could, and that's been the way it's always been done, is that you have done. I mean, you keep doing it that way, but this is the reason why you spend time really looking at what the implications, and what we don't want is unintended consequences that are going to seriously affect the administration of justice, which is the public, folks. I'm worried about my person who can't get into court to hear their case. I think you guys worry about that too, and it's important. And I would just implore you to take the time and invite the people really to the table and not in the preachy kind of situation that we're in right now. Open to any questions. Thank you.
Representative Blackwell.
Thank you. Is it Ms. Patton? Is that the name?
No, Ms. Benton.
Benton, I'm sorry. Ms. Benton, as representative of the Bar Association, I'm a little bit surprised. I haven't heard any reference by you or by the lady who spoke before to actual workloads of the courts involved. Would that not be a more meaningful way of evaluating what a particular district can handle and how many judges they need than to simply list for us the types of cases that every district court in the state handles?
Absolutely, I would agree with you, and I would say that we're a voluntary bar association. The state of North Carolina, at the administrative office of the courts, is the division and controlled by the legislature that keeps that information. I can tell you in my district, I can bring you all kinds of statistics about what's going on in the judicial district and what our numbers look like. That information is available. The other piece I would say about what the information is and how available it is, we need to talk with Judge Warren about, but some of the statistics aren't kept as well because our technology is so poor. We don't have all of the keys and strokes that we can keep all of the information. But yes, I can tell you the workloads are strong in lots of places, but I don't know every single division, I don't know every single district, but each one of those individual districts would be able to provide that information to you. Yes, sir.
Follow-up, Mr. Chairman. But all of that information on the workload is available to all of the volunteer members of the Bar Association, is it not? Is that private and confidential information that you all
I have
can?
no idea. The administrative office of the courts hasn't volunteered to give us anything. They've
Did
indicated
you
they've
ask
given
them
some
for it?
information to the legislature about that.
Did you seek to get the information?
I did not. I communicated with the judges that hold the courts across the state.
Right. One other question or comment. Another part of your preaching to us is, I think you characterized it,
Sure.
is that we're going to disrupt partnerships and relationships. Wouldn't it be fair to say that if we make any change in the districts, that that will occur and that that would have to be a given? So is it really an argument? I mean, I'm not quite sure how we weigh that. It's other than to say those people who are engaged with the system currently like the way they do things.
That's true, and that they could be done better based on various movements that may occur. And it all should be considered before you make a movement.
Any additional questions from members of the committee? Representative Lust?
Thank you, and I think your point on deliberation is well taken, and I definitely think we need to listen to people in the courts, but I do think, and the attorneys, but I think this is much bigger than them. I think somebody touched on this. This is about the administration of justice for the people.
I agree.
And I would ask you, if there was a deliberative system and we did everything you're recommending, I've got the current maps right here. Do you think it would be anything near what we currently have? And I know people in the system, this system are used to it, and any change is somewhat upsetting. But I'm just wondering if it's your opinion that this is anywhere near the ideal that we should have in North Carolina. And really, and I think about this in healthcare, I think this today, listening this morning, the choice isn't between the ideal and this proposal, it's between this proposal and what we actually have. So what is your opinion? Isn't it your opinion that we do need to make some major changes?
It's my opinion that we need to study it, and as a result of that study, I think you'll find that there would be good changes that need to be made and that would further the administration of justice when you have all of the stakeholders in place and look at how that works. And when, to the question earlier about workload studies, and just because there are X number of people in a certain area doesn't mean that you actually have X number of cases that come from that. Highway 95 coming through your county makes a difference in what your workload may be in different court levels, obviously, as with other issues that need to be looked at as you decide what would be the best way to put these districts and divisions together.
Follow-up?
Follow-up, and I agree with that. And I think one of the problems isn't just this bill, and I had many talks with former member Leo Daughtry on this, who was chairman of Judiciary and or Judiciary Appropriations. We really haven't funded the judicial system adequately, partly because you don't get that much political credit out of it when you spend that kind of money. But don't we need a deeper look at this? And I just wonder if you were around, I was just wondering this. I do, as a member, talking about the current system, I get a lot of complaints from the public deals with this, particularly from women who are in the district court system in domestic matters.
Absolutely.
I cannot tell you the number of times I get told the judge was unfair, the system's rigged, it's for the lawyers, the lawyer knew this judge and that judge, and I'm wondering if we need to look at the same issue that was the reason given for rotation of superior court judges in the district court system, that there could be home cooking, especially when one lawyer might have an in with this judge that another lawyer doesn't. And I'm just troubled sometimes when I'll get a lot of fundraising letters from candidates for judges, and there'll be a whole list of lawyers on the steering committee, and I've always wondered, thank God I don't do much in those courts, but I've always wondered if I were in court and the other side was an attorney whose name is on there, how would it matter? And I hope it wouldn't, but I'm just wondering if we're willing to go a lot deeper into the judicial reform movement than we're even doing here.
And the Bar Association has been involved in conversations about judicial reform and judicial selection. Those are the types of things you're talking about. We've been involved in that type of discussion for 50 years and would invite being a part of any types of discussions about that. As it relates to how your current districts and divisions are set, the Bar Association, as Ms. McNeil said, we are in favor of looking at them and looking at what everything, all of the stakeholders, how things, and the stakeholders include the public in a very big way. I hear you and totally agree 100% with that. And it's not only the lawyers, it's the sheriff's department, and it's the person who's trying to get their traffic ticket done. It's everybody that ought to have a place at the table to be a part of your discussion. It should be looked at and considered over some limited period of time. We would just submit, hopefully you look at it over the next, until May.
Follow up?
Real quick, who would be the stakeholder for the average Joe public in this process, in your opinion?
I think that on some levels, the Chief Justice, when he set up his Commission on the Administration of Law and Justice, put public people who are not lawyers on his commission, so he spent time thinking about how you would have representatives of the public in that way. I think in the individual judicial districts, your clerks of court, and the judges can submit to you the other public people, obviously your legislators know who those are. I see Representative Dixon, who is my legislator here, that they would be able to have input as to who the public people ought to be at the table with you.
Representative Rogers?
First, I wanted to echo what Representative Bliss said. I do think that we need to fund JPS more. That's a point that needs to be made every chance we get, I think. Also, I've been in a small district before, as far as district court judge goes, and way before Judge Brooks was my judge. But the selection was very small, and I think that the increased number of judges in a given district is a good thing, because for years we had judges that we would have loved to have gone out of district to get a judge back then, but that was way back in the day. Also, if you look at the number of lawyers on this committee, talking to the stakeholders, I think that attorneys more closely represent those stakeholders, being the public. And if you look on this committee, there's about 10 practicing attorneys on this committee. And if you look at people who work in the judicial system, there's probably about 14 of us in here that regularly work in that system. So not only are we representing those people as legislators, I think that on a daily basis, many of us are dealing with the individuals. So I just want to point out also that with the increased options for scheduling the judges in the larger districts, I think that's can also, you can look at it the other way. They can also increase the efficiency. So not only, some people seem to look at it as just going to make the judges drive farther. And that could be true in some circumstances, but it's also going to give whoever's doing the scheduling more options. And that could also increase efficiency.
Representative Jackson?
Thank you, Mr. Chairman. I just was going to follow up on Representative Bluss's comment about domestic court. And honestly, that's one of the changes about this proposal that bothers me the most is domestic court judges make a decision every day about custody. And in counties like mine, where we have 19 judges that run at large county-wide, every person gets to vote for that judge. And if we go to a district system, there will be people deciding custody cases who the plaintiff and the defendant before them had no right to have a say of who that judge was. And I agree with Representative Bluss, and that's one of the things that concerns me. And I'm also concerned with the way we're piecemealing this, in that some counties, some larger counties, are being divided into individual districts, and then other counties are being allowed to run at large. And it seems to me, as we go down this road, we decide, do we want individual districts, or do we want judges who run county-wide, and we need to stick to that across the state.
Any additional questions? Or, okay, thank you both very much.
Thank you.
And I do believe, just want to recognize them and give them an opportunity if they'd like. I see, I know of at least one additional judge that's here, Superior Court judge, but I believe there may be a couple. Just to give you an opportunity, if you have anything to add to the committee, you're more than welcome. If you're a district Superior Court judge and would like to do so, come to the microphone and do it. All right, I think anybody wants to, all right, here. One brave soul. Please, if you will, state your name and your title and the district you're from for the record, please.
Thank you, Chairman Burr, legislative members. My name is Robert Steele. I'm the Chief District Court Judge in the 12th Judicial District, which is Fayetteville, Cumberland County. It is a single county district. About 1/3 of a million folks live there. Our courthouse runs about 72,000 citizens each month that come through its doors. We'll do 2,000 or so domestic violence, civil protective orders in our district courts. I've been a judge for 23 years now, elected spring of '94. For half of the time on the bench, I was the only judge in Cumberland County that was put to work in a contested election. As Chief District Court Judge, it's a privilege to speak with you. All of my 23 and a half years have been spent in domestic court. I've been certified as a family court judge, certified as a DSS juvenile judge, certified as a juvenile delinquent court judge. So literally, families, children, lives are my life's work. And I'm very grateful for that opportunity. I've also, and I would encourage you to take a look at the Celebrate NC Courts website. I'm the ex officio historian who has written the 2 pieces on the history of North Carolina courts and also the history of our district courts in recognition of a number of milestones that we are in the midst of. The 50-year anniversary of the formation of our district courts in 1966, the 50-year anniversary this year of the establishment of our Court of Appeals, the 240th year for our superior courts, which were established by act of your legislative body back on November 15th of 1777, and then the 200th anniversary next year of our Supreme Court. As I listened, many of the questions that were asked were very pointed, very legitimate. I believe we all have the common ground of providing the best system of justice for our citizens. I think we're all find common ground in realizing that 50 years, 60 years now in examining districting and the issue of our courts, it's time to take a look at things. I have found a number of the answers rooted in the history. We've talked and heard from Superior Court judges that by legislative act, there are only 3 that your body created back in 1777. You also designed 6 districts. These 3 judges were to hold court 2 times a year in 6 districts, 6 cities, and they were circuit judges because literally they rode the circuit on horseback or buggy, and they could not take the same route 2 times in a row. And hence our Superior Court judges still retain to this day that notion of riding the circuit. As a district court judge, we had the opportunity in Cumberland County to, on August 8th, have Representative Burr come in and speak with us about the proposal. Again, the judges, I think on the whole, it's not an issue of examining what we have and making improvements upon it. Cumberland County, by way of example, has 10 district court judges. Of those 10 judges, 7 of them would fall under the District 15B if they were called upon to file for re-election next year. Our county essentially would be divided into one 15A city district, Fayetteville, and then 3 other quadrants that would comprise 15B. 3 of the 5 current judges would reside and run presumably in 15A. 7 of the existing judges would presumably run for 5 seats in 15B. All of our judges, I will say, reflect our community. I understand the divisions, proposed districts are broken up by population, but we may have what may be the most diverse district in the state. Currently, of the 10 district court and 4 superior court judges, we have 7 that are African American, 6 that are white, 1 that is Hispanic. The population breakdown almost is identical, absolutely identical to that existing percentage of folks involved. Of our 10 district court judges, we have 1 African American Korean, 1 Hispanic, 5 African Americans, and 3 white males. I fear that should we take at least Cumberland County's district, divide it into a 15A, 15B, that we would no longer have a bench that not only is diverse, but truly is reflective of the society, the community that we hold court in. So I simply am here to say thank you for this common interest we have. We look forward to your work. And then lastly, in looking back, there's much talk of the Bell Commission, J. Spencer Bell's commission. This was a movement that began in 1955. The governor, Luther Hodges, was involved in it, the North Carolina Bar, clearly the state legislature, the judges at the time, who would tell you the 1,500 different types of courts that were in existence in 1955, with a hodgepodge of jurisdictions, how they collected their pay for the judicial officials, whether they traveled or not, simply was not working properly for the citizens. And it took the Bell Commission 4 years, and they went to the legislature, and it took the legislature in 59, in 61, in 63, and finally in 1966, adopting what we now say we haven't looked at things in the last 50 to 60 years, and it's the time. It was a deliberative, concerted effort, and it has spanned 3 generations in success, and I think that formula of looking backwards at history and looking forward to how we can best design our legal system commands that same method and attention. And I know the commitment is here, and I thank you for it. Thank you, sir.
Good. Any other district superior court judges here that would like to add any additional comments? All right. If not, that'll conclude that section of the agenda. At this point, members, you've had passed out to you, and all the documents are online. at this time as well for anyone listening in. You've got the map, one map that was passed out to you last week, which are the existing Superior Court, District Court, Prosecutorial District, and Judicial Division lines on one map. And then you've also got House Bill 717, the second edition, which was heard in Representative Davis's committee back in June. And I would encourage you all to look at that and to certainly continue to provide feedback or ideas. Certainly the comments we heard today from the different interested parties, we'll take that into account as we work to develop a proposed committee substitute, but along those same lines to hear from the committee. I want to also speak towards Representative Jackson's comments earlier, just to make clear as the intent of House Bill 717, what's been proposed, the efforts have been made, and really, I guess as well speak to some of the comments that were made earlier, the Bell Commission and those things. This committee and House Bill 717 in no way is attempting to disrupt the structure that they proposed. We're simply 60 years later looking to update, modernize, to clean up those districts that have seen 60 years worth of piecemeal changes that have created a really, what I see to be districts that are inefficient and resources that are in the wrong area that could be better utilized, as was mentioned by a number of our committee members, where we have limited dollars in the judicial branch, to take those limited dollars we have and to make sure that they are spent and utilized as efficient as possible and in the best interest of the taxpayers and the folks that go before those in the judicial system. And certainly that is what this second edition attempts to do. But based on the comments we've heard here in committee and the comments that I have received as I've attempted to travel the state to meet with judges and judicial leaders across the state to incorporate in other ideas, changes, proposals that would help to help with implementation of this, and to make sure that we are being consistent so that urban counties in this state are all treated the same and have the same manner for electing their judges. Those rural counties is the same structure there as well for the rural areas, and to actually have that versus what we have today under the existing structure, which is very much piecemeal and disjointed in a lot of areas and in need of repairs. And I certainly respect and hear folks that are okay with the status quo and want to protect the existing structure, but I simply would vehemently disagree with them about the fact that to me it's not acceptable to have a judicial district like we have in Mecklenburg County, where there are 7 Superior Court judges. And in those existing 3 districts, if you look at that map, you've got that orange district there under the current map, where 450,000 individuals reside and are served by their judges. You've got the District A and B, one of which has 300,000 residents in it, the other 150,000. District C, and I believe it's District A, both elect 2 Superior Court judges, even though one has 450,000 residents in it and another has 150,000 residents in it. That is, I believe those voters are being disenfranchised, and that's not right. And we have an opportunity to correct that. Quite frankly, this didn't happen overnight. And if the leaders of these different groups that have stood up and spoke today, if this is something they felt strongly about addressing, it should have been done earlier. And we all are elected to a 2-year term. We have responsibilities, and I believe this is one of our responsibilities that we need to take up and correct these maps and make sure that the voters in these areas are not disenfranchised, that these judicial districts are set up not for the benefit of lawyers, but for the benefit of the people of the state. That's what we're discussing here. And I will certainly ask for members of the committee to continue to provide feedback. Would ask for the same from the public, from judges, those I have met with, those perhaps haven't had an opportunity to yet, but certainly welcome that feedback as we continue to work to move forward to develop maps that serve this state and continue to keep that structure that was established by the Bell Commission and make sure that we are able to see that justice is served in this state. Are there any questions at this time about the proposal or where we're moving forward? I will tell you it is the chair's intention at the next meeting to bring to this committee a proposed committee substitute and incorporate in some of the changes, as I said, that I've heard across the state, that I've heard from some of you all, and heard from those members of the public and others who have spoken today and at other times. So, any questions or comments, Representative Davis?
Thank you, Mr. Chair. Would it be possible for the members to get a copy of that proposed PCS before the meeting so that we could
Yes, sir.
digest it?
Absolutely, that will in fact be done, and I will let the committee know as soon as we're able to establish a time for us to have that meeting. We'll get that notice sent out to you as soon as possible. But I want to make sure as well, I believe you have a committee next week. I know the Courts Commission's meeting. We want to make sure that our committee, that we don't have any conflicts and that all of our members can be here and continue to participate in the discussion.
That would be next Thursday.
Yes, sir. Representative Blunt?
Have you had any discussions, or do you have any feel for what the Senate view on this subject matter is? Because anything we may pass, if it passes the House, would go over there, and who knows what they may do, but I'm thinking it would probably be at least May before the Senate even took this matter up, would it not?
Representative Blust, both bodies in the adjournment resolution last month included the judicial redistricting as legislation that can be brought forth in the October session. So certainly it is on the agenda for the legislature, and we'll have to determine that time how things proceed. But I'm certainly optimistic that we will move forward with the plan. Representative Blackwell, did you have any additional questions from committee members? Representative John?
Yes, sir, Mr. Chairman. Has a fiscal note been requested or prepared with reference to House Bill 774?
Representative John, I believe there was one to the old edition, but I can double check that, and we'll attempt to make sure that we have one for the new edition when it is completed and brought before this committee.
Thank you.
Yes, sir. Representative Moore?
Thank you. Representative Byrd, with these new maps, is there any more finer details so you can tell exactly where the districts are broken up, especially in the 9 county districts that are now split into separate? Like, it's hard to tell where exact division is.
You should have as well, I believe, the individual maps that are there. Are you asking for individual county breakouts of the?
Yes.
Make sure I'm clear. I want to make sure I answer your question correctly.
Thank you. I think there are 9 current single district county maps for district court that are now divided up. Is there any way to see where the divisions are within those districts?
Yes, ma'am.
So current judges will know if they're in a new one or an old one?
There are individual maps that can be provided for that, and I'll make sure that those are sent out. If you want them on these current maps, we'll make sure they get the current proposal, get those to you, and I'll also make sure we have those for you when we return with a new PCS as well. Yes, ma'am. Representative Torben?
At this time, is there an assumption that the meeting next week will again be on Tuesday?
No, sir, not at this time. Any other questions? All right, if not, thank you all for your time for being here today. Committee stands adjourned.
You got a motion?